Mic check. All right. We are live. Oof. All right, everyone. It is 6:15 for those online. If you want, you can write in the side chat here, and I will answer your questions as they come up. Just going to do a quick mic check to make sure you guys can hear me out there in the interwebs. Nope. Just be mic. Just be audio. Okay, we are all good. Sorry about the wait. If the people online couldn't hear me, this would be a very bad thing. So, what are we all here for? Oh yeah, for constructs. I almost forgot. We're doing constructs tonight. All right, so first thing I want to say is thanks for coming. And the second thing I want to say is evidence was hard. Yes, I know. I know it's hard and long, definitely. So I want to make sure everyone felt that way. Everyone complained. So if you felt it was hard and it was difficult and it was long, you are not alone. Everyone did. So, hopefully you've gotten over that madness. Test hard, grade easy. That's what the professor told me to pass on to you guys, Yes, so if you felt that you were a little struggled, don't worry. Everybody struggled. Now, I should have been more cautious when because I took the test before you guys took it, and I missed 3 of the multiple choice, but I was like, hey, these might be poorly worded questions. I sent it back. We changed it up a little bit. And the test was actually, we thought, shorter than last year's test, but obviously it wasn't because of the whole feedback. So yes, so if you feel like that test was a monster, it was not for just you, for everybody. So, have solace with that. And the professor knows that. We have research, we have looked at it, and things will be adjusted accordingly. Second, family law. Is anybody here concerned with family law? If you are, I understand. I just sent out all the rules, 2 packages. One I just sent out maybe 5 minutes ago. The second one I actually sent out a little bit earlier. Question? So you'll have those rules, the 2 sheets of paper I sent out, excuse me, like 6 sheets, but whatever on that paper is going to be on the test. If it's not on that paper, it's not going to be on the test. The test is also going to be open book. So obviously you'll be able to use that and write it in your own way, and it will be open book. The thing is going to be like 2 essay questions and some multiple choice. I'm not sure she's going to allow you to do online. I think she doesn't like, because the professor said last time for the midterm it was going to be Control F, so she didn't want to Control F. So I think you're going to be able to it's going to be like open notes, and I think instead of open book. But I know you will be able to bring an outline, a full outline, or whatever notes you guys have. If you're going to print something out. Last time she printed out the entire book for everybody, so I'm not sure if she's going to repeat that, but I'll ask her. And for those who don't know, Sunday is the review for family law. So we'll be here 2 o'clock for family law. Doing the same type of setup. We will be both online and in class. All right, so I've dispensed with all that, and now we're going to constructs. So for constructs, we're going to go over the 2017 exam. Now, I'm assuming everybody here read the 2017 exam. And what we're going to do is I'm going to use some tips and tricks on how best to issue spot. We're going to look at how the professor grades and what you need to keep your eye on them and and what's important. If something is only worth 1 point, it seems like it'll be less likely that you'll spend a lot of time on it versus something worth, 10 points, for instance. So and Professor Gomez-Velez's grading really helps us understand what the best way to prepare for the exam. So I'm going to spend a lot of time on that. So today, this is what we're going to be doing. We're going to be looking at the call of the question first. from the 2017 exam, I say this: whenever you're taking one of these exams, you should start with the call of the question, because it's going to help you read actively. You're going to know what you're looking for and read through the fact pattern. Now, a lot of times students read the fact pattern 2 or 3 times. They'll read it first when they get the paper, then see the call of the question, then say, okay, this is what I'm looking for, and then have to read it again. That wastes time. If you do that on the bar exam, that's going to waste time. So reading the call of the question first helps you at least identify what you're going to be looking for in the fact pattern. And then when you read actively, you can then take little margin notes to know, okay, these facts are important for this particular issue. So secondly, we're going to look at some of those key facts in the fact pattern just to see how we're going to address them. Then we're going to evaluate the model answer that the professor gave us, issue, rule, application, and conclusions. So this is how we're going to do it today. It's going to take a little time, but just work with me. And also, I'll send this out via, I'll put this on Twin. I'll send this out via email on Twin. Okay, so here is the, I'm going to close this out. What is this doing here? Okay, so here is the call of the question from the 2017 exam. 3 questions, 25 points, 25 points, and 10 points. So it's 60 points. These actually the points that you'll get for the end of the class, 60 points. And it says, is the ADA a valid exercise of Congress's power? Please fully explain. Does the ADA preempt the Wyoming WCA section 27E, blah, blah, blah. Please explain fully, 25 points. And then we have, is the HOSPI barred from bringing this action under principles of state sovereign immunity? And that's going to be worth 10 points. So what can we find out based on this understanding? 1 second, let me make sure I pull up this. Okay, cool. I can hear loud and clear out of here. All right, cool. Oh, I got people typing in the chat they can't hear. Hopefully you can hear, because I've tested it, so I know you can hear. But some people are saying they can hear, and some people are saying they can't hear. All right, so this is the call of the question. So let's look at each one individually and see what's up. So the first one about the ADA, is the ADA a valid exercise of Congress's power? So we've only really learned 3 ways that this actually can occur, right? From Article 1. We've learned about the Commerce Clause, necessary and proper, and taxing and spending. So it's probably going to be one of these 3 going into it. Which one? We don't really know as of yet, but we're really looking at this one. And I can really say it's really not going to be number 2, necessary and proper. Because the necessary and proper clause is I like to call it like the conduit clause. It's one of those things where if you're exercising the power of commerce or you're exercising the power of taxing and spending, the necessary and proper clause is like that bridge that allows you to exercise that power through some law. So this law I'm using is going to help facilitate me exercising the commerce power, the taxing and spending power. So that's really what we're looking for. If you see something like this, an exercise of Congress's power, you're really trying to figure out, is it one of these 2? Valid exercise of Congress's power. And we have a statute here too. Oops, sorry. Number 2. Oops. How did I miss number 2? I think I deleted the second one. I did delete the second one. All right. The second one, I'll go back to this then. The second one is a preemption statute, obviously. Does the ADA preempt the Wyoming statute? So we're looking at preemption. And then the third one is HOSPI barred from bringing this action under the principles of sovereign immunity? And that's really the 11th and 14th Amendment, sovereign immunity. 11th Amendment's a bar, and the 14th Amendment is the Section 5 abrogation of sovereign immunity. Did I talk too fast, or are you guys with me? So here's some of the key facts for the first question. This is the ADA, the Airline Deregulation Act, and it provides that a state political subdivision of a state or political authority of at least 2 states may not enact or enforce a law, regulation, or other provision related to the price, route, or service of an air carrier that may provide air transportation under this subpart. This provision does not apply to the legitimate exercise of state police powers essential to public safety and health. So this screams to me Commerce Clause, right? This is not taxing and spending, right? This is Commerce Clause, because it could only be one of those 3 things that we saw earlier: commerce, necessary and proper, and commerce, necessary and proper, and taxing and spending. So this screams to me to be a commerce Clause issue. Does anybody have anything different? Does anybody have any other feelings of why they don't think this may not be commerce? Go ahead.
Well, you mentioned that the necessary proper is basically vessel.
Yes.
Kind of what we have to lay that information in our answer if we're using commerce clause.
Very astute. Yes. And you'll see that. You'll see why. So we know that we're looking for the commerce clause in part 1 of this essay question. And this is what the professor says were triggered by the first question. The commerce clause, the necessary and proper clause, the 14th Amendment, and I put 10th, but it's actually the 11th Amendment. So this is what's triggered in this answer. I'm sorry, it is the 10th Amendment. I don't know why it's 11th. This is what's triggered. Now, for those of you who read the fact pattern, did you guys get all of this? Did you guys get all of these things were triggered within the fact pattern? It's okay if you did. It's all right. No, I see no, I see yes, I see yeses and no's. No, right? No. That's a lot, right? Now, most students would have only just done a commerce clause analysis, right? You do the commerce clause, it's obvious. Let me just do the commerce clause analysis. But this is what the professor, in her answer, said all of these issues were triggered. So let's see why. I also, before we get to there, I also wanted to make sure we see the point allocations for each one of these. So the commerce clause, part of it was 15 points. The whole question was worth 25 points. Commerce clause was 15. The necessary and proper clause was 1 point. Like you were saying, do you have to talk about it? The 14th Amendment was 2 points. And the 10th Amendment was 7 points. So if you just did the commerce clause, you would have got a little bit more than half the points, but you'd have to been perfect on the commerce clause too. So let's just start with the commerce clause. So here's the rule for the commerce clause, and I have up here in red rule and 8. That's how many points she gave for just the rule here. 8 points for the rule alone. Question? Yeah, I'm gonna send them out like right after we finish this. I'm emailing them straight to you guys. I should have emailed them before so you can just follow along, but it's okay. We'll suffer through this. So this is the professor's understanding of what you need for the commerce clause. Now I would say this: if you're doing a commerce clause question, you want to replicate this as much as possible. So here you have a little background on what the commerce clause is, right? Enumerated powers, state legislature. And you see this is what you were talking about. The legislature in the first paragraph here, Congress legislates pursuant to these enumerated powers together with the necessary and proper clause. So that's why when you're using the commerce clause or the taxing and spending clause, you do want to mention the necessary and proper clause within your analysis. And here she does that. And that first little paragraph is worth 3 points.
That's with the 1 point.
No. We haven't even got there yet. This is just the 3 points that she gave for the introduction to the commerce clause. So this is 3 points right here. That's where you see that number at the end. That's what this is. The next paragraph is 5 points. This is the test for the necessary and proper clause. Article 1, Section 8, Clause 3. You don't need to know all that because remember she said you didn't have to put all that, but you do have to put the Constitution authorizes Congress to regulate commerce among the several states. And then she gives the 3. After she goes here, she gives the 3 ways, channels of interstate commerce, instrumentalities of people or things in interstate commerce, and 3 activities that have a substantial effect on interstate commerce. And then she describes in determining whether an activity has a substantial effect on interstate commerce, courts consider not merely whether a single instance of activity has a requisite effect, but rather whether the aggregate impact of all the activity nationally can reasonably be said to have a substantial effect on interstate commerce. Just by saying this, restating this rule, you got 5 points. So 8 points for the test, and we really just got 2 paragraphs now. So gobbling up those points, like Pac-Man. And that's just for the rule. We haven't even touched the rule explanation yet. So now, we know this is 15 points. We got more than half just for this rule piece. How much do you think the rule explanation is going to be worth? 7? 2 points. And this is the rule explanation. So this is the 2-point rule explanation. Yes, and I sent out this her model answer, and this is the 2 points. Now it goes into the history of the Commerce Clause. About, you see how it goes into Wickerby Filburn, the wheat case, right? Then it goes into Lopez and Morrison, explained. So it takes the effect of having a broad we go from having a broad understanding of the Commerce Clause to being restricted in Morrison. We go to what the difference is substantial effect. She talks about economic and non-economic. All of this is telling us how the Commerce Clause has worked over the years, how it went from very broad to how it went from very narrow. And this is worth a wonderful, illustrious 2 points. Did you get all that? Questions? Any questions?
I'm just curious. Let's say if you would just mention one case for rule explanation,
Mhm.
you think you could get 1 point at least?
Say it again?
You can get 1 point if you just mention one case for rule explanation?
Maybe. But this whole thing is worth 2. But now, as a lot of you start, thinking about, Commerce Clause, rule explanation. This is a lot, but she's only given 2 points for this. This is great. But again, it's only 2 points. So let's go. So next piece. So now we have 10 of our 15 points are gone. 2 points for here, 8 points for the rule. So now we've got 5 more points left, and that's in our application. This is what she looks for the application. This is, again, this is her under this is her grading rubric. And now let's. I'm not sure it's going to be the same test, but this is our understanding of how she's allocating points, and we'll see this. We have 2 more questions we'll see to see if it's consistent the way she's allocating points. So here, the ADA has authorized under the Commerce Clause. It involves the regulation of a channel of interstate commerce, like airlines, railroads, and highways, which it is, right? The ADA, from this fact pattern, is regulating airlines, highways, and railroads. Actually, it's the transportation of the hospicare. It cites a case, Gibbons. It says here, like Gibbons and B. Ogden. This also qualifies as regulations of instrumentalities of interstate commerce. The helicopters, for instance. Regulations of airlines and air travel is squarely within Congress's commerce power. Congress, under the enumerated commerce power and the necessary and proper clause, which we haven't talked about yet, is authorized to regulate price, route, service of air carrier that may provide air transportation. 5 points. So here, Commerce Clause, what is it? They told us. And this, it was clear. It's an instrumentality of commerce. And on top of that, it's a channel of interstate commerce. It's regulating them both. And as we know from the Commerce Clause, the government's power is at its maximum if you're regulating both instrumentalities of commerce and channels of interstate commerce. 5 points. So, understanding, seems like the bulk of these points are going to be for your rule and your application. If you just did rule and application here, you'd have just missed 2 points. But you need to have a rule explanation because, again, the rule explanation she finds to be an important piece. So if I would say don't leave those points on the floor. If you can, give a little background. Remember, it's a kind of like a historical perspective on how this rule came about and why the court comes to the conclusions that it does. Question?
For 2 points.
Again, just because she graded this way before doesn't mean she's going to grade this way next time. But again, we'll see more examples. So again, I wanted to also put down here. Here's the Commerce Clause, right? The Supreme Court has interpreted the Commerce Clause as empowering Congress to regulate. And this is actually from the top. This is actually from the rule. I just put it in this outline format. So here, the highlighted portion, channels of interstate commerce, instrumentalities, or people or things in interstate commerce. That's just from the rule, broken down this way. And as you can see, the 2 highlighted portions here and here are the same. So she's saying, she's not even talking about this last piece. She's just talking about the first 2 because that's the only thing that's actually that it fits squarely within those first two. So didn't even address the last one. And this question is done. Easy, nice. Well, not this question, this first piece of it, because now there's still 10 more points out there, right? So let's see where those other 10 points are at. So we dealt with the commerce clause for the first question. Now we're going to go into the necessary and proper clause. Now we all know it's 1 point. So let's see. Give me an hour. So now we're going to see how the necessary and proper clause gives us out that 1 point that we need. Oops. Oh, this is the breakdown. I'm sorry, this is the breakdown of the rules for the commerce clause. But as you can see it, rule explanation, and application, total 15 points. So commerce necessary and proper clause is 1 point. And here's the 1 point. Necessary and proper clause, briefly note the rule of the necessary and proper clause. So what's the rule? And note of the necessary and proper clause, clause is giving Congress, I shouldn't stay right here, the latitude of enacting legislation that enables it to carry out its enumerated power, and that the legislation being within the scope of Congress's commerce power, it also supported by the necessary and proper clause. That is 1 point. Give her the rule, give her this statement, and you got your 1 point for the necessary and proper clause. Now, question. If we were doing taxing and spending instead of commerce, do you still do this? Yes, right? If the question triggers the taxing and spending clause, this still applies. You do this, so no matter which one, if you're doing commerce or you're doing taxing and spending, you're going to apply this rule. One point done. Now 14th Amendment. Now this is where I'm going to have to talk to the professor, because I did not think this question triggered the 14th Amendment. I didn't think about it at all. I was like, no, this is, like, what? So when I was typing it, I was like, it triggers the 14th Amendment, but I went through and I said, okay, it triggers it. So guess what? If this was taxing and spending, would I do a 14th Amendment analysis too? Yes, because this is all part of this commerce. Commerce clause is the big analysis, but these are other ways that we can actually see if this statute is valid, because if it violates sovereign immunity, the 14th or the 10th Amendment, then we'll have an issue, because we're trying to say, is this valid? Here's the 14th Amendment. Again, the first, she gives you 1 point for this. Section 5 of the 14th Amendment. So now we're telling about the 14th Amendment, enforce civil rights provisions, about section grants Congress broad power into Section 5. She explains about the goals. So this is rule and rule explanation. All for the 14th, right? Congress may remedy or prevent or deter violations of the 14th Amendment, and it may prohibit conduct that is not in itself unconstitutional. So here we go. 1 point. Nice little background on the 14th Amendment, kind of lay it out, tell us what we want. And then the last point is for this sentence. This sentence is worth 1 point. The statute in issue does not implicate the 14th Amendment because it does not operate to enforce its provisions, right? This hospicare statute doesn't deal with any equal protection claims. It doesn't deal with any 14th Amendment issue. So this doesn't apply. Therefore, Section 5 of the 14th Amendment is not a source of authority for the statute. So it seems like, from what we're looking at, the professor is looking at this as, is there anything that I can use to as a source of authority for this statute? Section 5 of the 14th, necessary and proper clause, and the 10th Amendment. So she's looking for all these different sources, and this is one of the ones that she says doesn't apply. So this one doesn't apply. 1 point.
Say that it does not apply.
To say this one sentence, you get 1 point. Well, she gave 1 point in 2017. This was 1 point. The background, the rule, understanding how it works, and this was 1 point. Again, she's saying it is, so it is triggered. So if this was a taxing and spending question, would you do this analysis? To get your 2 points. This one is worth 2 points. So now we're moving on to the 10th Amendment. And now we had talking about some real points here, 7 points out of our total of 25. So here we break it down a little bit more. 10th Amendment, first the rule for the 10th Amendment. 10th Amendment operates as a limit to Congress's power to enforce legislation against the states that violates federalism principles by encroaching on state sovereignty or by commandeering the state to operate on behalf of the federal government. This is your rule. This is 1 point. Question.
10th or 11th?
This is 10th Amendment.
I thought you said 11th.
I know I made a mistake. I said I was thinking 11 for some reason, but this is 10th. For some reason I'm getting state sovereignty, but this is federalism. I apologize. For those online too, I'm sorry. I meant 10th. It was 10th. Quick question. What can we bring to the exam? I'm not sure. I think you can bring, maybe, and your computer, and if you've had to take exams before, you can probably bring your computer too. I don't think you could bring, if the question really is about bringing outside like your outline, I don't think you can. I think it's a closed book exam. I'm not sure. Do you? She said you can Constitution.
In this, it says that there will be.
Oh, so there'll be excerpts of the Constitution provided with the exam. That'll be great because then you could just literally write that out from the Constitution, right? But you'd have to kind of know a little bit more of this too, because this whole encroaching on sovereignty and commandeering. So that's 1 point. This is 1 point. Rule explanation. This one is worth actually 2 points. It shouldn't have been 7 here. This is worth 2 points. So this is how she's explaining the rule. She goes into the cases that does not run afoul of the 10th Amendment federalism problems because it does not require states in their sovereign capacity to regulate their own citizens. She gives some page numbers. Even though you don't need the page numbers, don't freak out with the case cites and the page numbers. You just need to understand this is the rule explanation, how the rule has worked, what the court has concluded about this particular principle of law. And here she's using the cases just to illustrate how the court go from either broad to strict or from strict to broad. Now we go talk about the application. And here, this application is worth 4 points, which is the biggest bulk. More than half the points is here with the application. And this says here the ADA does not require states in their sovereign capacity to regulate their citizens. It prohibits states from affecting prices and other matters. So this is a long explanation to say that this doesn't apply. See, even at the end, the application from its legitimate exercise of the state police power, it is unlikely that the court will, actually I got to read it from this one because this is cut off for you guys here in the room, find that the ADA does not violate the 10th Amendment. So here we've gone through, so has anybody in here been surprised by the point allocations so far? So now, but again, this is going to change the way you study for this test now, right? Change your understanding. Even though cases are important and understanding how we got there is important, but the points are really with the rules, right? And the application. Rule explanation is important because obviously even in some of the application, what this professor is doing is asking you to take the fact pattern and say, is this fact pattern more or less like the cases that we had? There's a case that says, yes, you can do it. Are the facts here identical to that, or is it different than that? If it's different, then the court's going to find, like in, I forget what case I'm thinking about. I forget what case it is. Anyway, only thing you're doing is actually comparing the facts of the facts that you have in a fact pattern with the facts in the Supreme Court case. If they're identical, you're going to conclude the same way the court did, or you can distinguish and say they're not like this and say the outcome would be different. And that's the rule explanation piece. She did, so I got a question. She did mention that we will have experts from the U.S. Yes, but no outlines. Yes, I mentioned that. Yes, you are correct. Minnie Nicole G. Oh, is that multi Nicole G? All right. So now we've done our analysis for this last one. For the rule, we got a point. Rule explanation was 2, and the application was 4 to give us 7 points for the 10th Amendment, and we're moving on. So we got our 25 points, hopefully. Now, here, most of you would have been stuck with the Commerce Clause and just did that, got your 15 points, and been moved. But now you know, you got to throw in something for the necessary and proper, 10th Amendment and the 14th Amendment. And I would say this, last slide on this, whenever you see this in red, a valid exercise of Congress's power, you know, if we're talking about taxing and spending or Commerce Clause, you do these last 3 together with that. But that makes sense though, right? Because no one would have thought these things would have been triggered, but they were triggered because these were trying to find out, are these valid, you know, is this a valid exercise of congressional authority? So we're going to try to use these other 3 too, to see if we can go.
Because you mentioned it's not a bounty class, if you're not sure which rule is triggered, both, would you recommend that here?
I would, because this is a positive point test too, but that may get long because these, like the Dormant Commerce Clause rule is long, you know, these you might just, you know. So I would say this. This is one of my best hits. You know, I'm going to give you my best. This is one I think is right. And if I have time afterwards, I may then say, but also this may apply. But here, I wouldn't do that. I wouldn't do that because I kind of know if I see valid exercise of Congress's power and I have a statute, then I'm here. And I know I got to speak to necessary and proper. It's going to give me a point. Even if I just, you know, even I fumble it up, I'm going to get a point for even just saying it. 14th Amendment, 10th Amendment. And then either we're taxing and spending or commerce. So we're done with number 1. And now let's move on to preemption. So when we first look at this and we saw preemption, the reason why we're not looking at the Dormant Commerce Clause is because we have a statute. The Dormant Commerce Clause is when Congress has not acted, right? So we have the ADA. So, and I don't know why she named it the ADA. I keep thinking like Americans with Disabilities Act, and it's just blowing my mind away, right? Am I the only one? Yeah, I'm like, why am I? It's like, it's just so confusing to me. But it's the ADA. All right, so now we're trying to figure out, is the WCA, Section 27, is it preempted by the ADA? So we know we're looking at preemption of state laws, and we know we're not looking at Dormant Commerce Clause. So it's important to understand these triggers because this test may test the Dormant Commerce Clause. So you may not have a statute. Uh-oh. Oops. Let's see what's up with my slides. Oh, yes. I know what happened. Cool. Sorry. That was my switch. All right. So now I want to take you to the professors. Now this is the professors written out because I didn't want you guys to think I was writing this thing out. These were mine. So this is the professor's grading rubric and how she expects this second question to be answered for 25 points. And again, I've already sent this to you, so you already have this. And the slides, you'll have the slides. So with this, well, you'll see things in red marked. Those are my markings because just going through this just to see how the professor is looking at this example. So this is, does the ADA preempt the Wyoming Workers' Compensation Statute? So the first thing is the rule is 3 points. So we get 3 points for the rule. And here's the rule. Well, I'm sorry. This is an overview of the rule. I count this as the overview of the rule. So this says there are 2 cornerstones of preemption jurisprudence. Now she puts a full cite here, and as soon as I saw it, I was like, this is going to scare the crap out of me because I'm not going to remember this cite. But remember, she said you don't have to have cites, so you don't even have to have this name. But you do probably have to have something about the 2 cornerstones of preemption. Understanding that the first, the purpose of Congress is the ultimate touchstone in every preemption case. Second, in all preemption cases, and particularly in those in which Congress has legislated, in the field which the states have judicially occupied. We start with the assumption that the historic principle, the historic police powers of the states were not to be superseded by the federal acts unless it was a clear and manifest purpose of Congress. So this understanding is what she's looking for as like an opener. And it seems like just, this is kind of how it all developed. This is 2 cornerstones of jurisprudence, and this was worth 3 points. Now, I'm going to be honest with you. I missed these 3 points. I didn't say this. But if you get a question like this, and we notice what she wants us to say, I think it would be good to put this in our outline to understand. This is probably something that we'd want to say if we get a preemption example, because she gave it 3 points. I didn't say it, but I would have missed these 3 points. But now we know this is what she's looking for. Moving down. Now, also you'll see the bold. That's actually me just breaking it down a little bit more. So, express preemption, because remember, we all know the rule for preemption: express, implied, preemption, and we'll touch on that as we go through. So this is now express preemption. Express preemption. She puts Lil or tobacco in brackets. Where the federal statute expressly preempts state, local law, and the subject matter area. Boom. That's what you need for express preemption. Then she explains it. For example, and what is it called? How do you say that? Is it Lorelad? I'm like fumbling my L here. The court ruled that federal law regulating health warnings and then advertising of tobacco products expressly preempted state regulations. BC is because language prohibited states from enacting similar legislation. Boom. All right, Nicole. Now I know. So that is express preemption. That was worth 4 points. That's a lot. Now remember how much the rule explanation was up top, right? That was like crazy. This, she's saying, is 4 points. Implied preemption. Implied preemption, otherwise known as conflict preemption. This is about the impossibility. She gives 2 examples. You look at Florida lime or avocado growers. No impossibility of conflict. That's what those 2 cases stood for. So that's what she wants you to compare. Well, in these 2 cases, there was no possibility of conflict. California 8% oil requirement and a federal avocado mature rule, not referencing the oil. Obstacle to preemption, and the case was Pacific Gas. Nuclear waste disposal plan requirement before new nuclear plant can be built, not in conflict with the AEA. So conflict preemption, for those who don't know, is when federal law, you can't, where by applying, I don't know why I keep fumbling this up, by being regulated by one, you'll be in conflict with the other one. So by following state law, I'll be in conflict with federal law. By following federal law, I'll be in conflict with state law. And that's where you get your conflict preemption. And then we have field preemption, which is the last piece of this. Oh, and again, that was worth 4 points. And field preemption is preempting the whole field. Preemption is where Congress occupies the field. Congress may draft legislation designed to occupy the field in certain areas. That is, where federal law is meant to be the only operative law. That is your rule for field preemption. And here's your rule explanation. Again, gives you examples. Sabellis with Arizona. Again, this is examples of field preemption. And this, again, is worth 4 points. Again, this is before we had this huge rule explanation only worth 2, but here we're just talking about simple 2 or 3 paragraphs. And you're getting 4 points for them. But again, you're explaining the rule and the rule explanation. Now she doesn't divide which one is worth, she doesn't say this is worth 2 or this is worth 4. This whole thing is worth 4 points. So just understanding this is what she's looking for. This is her rule and this is the rule explanation. And as a running theme, the rule explanation has always been how the rule is developed over time. This is an example of how the court has applied this rule. That's what you're looking for your rule explanation. Here, the court applied it this way. Any questions? Because I know I'm talking fast. I feel like Donald Trump giving an interview right now. We're all good? Oops. All right. I don't know. You guys are like playing poker with me. Everybody's like, it's so stone face out there. All right. Here we go. Note, 15 of the 25 points are for the rule and rule explanation. So here, 15 of the 25 points for rule and rule explanation. It's a lot of points just for the rule and rule explanation here. Now let's go down. Application. Express preemption, 3 points. Here, there does not appear to be express preemption given the safe harbor. The statute's provision prohibiting states from enacting or enforcing laws, regulations, or other provisions related to price, route, or service of air does not squarely preempt the state law in issue, should be at issue here. 3 points. Concise, clear, this doesn't apply. We usually would call this raise and resolve, right? This has been raised and resolved. 4 points for bringing up the rule, 3 points for closing it out. Open the door, here's the rule, we closed it out, we got 7 points. Like a man with a question on his mind. All right.
Nate, when you send the slides, could you send this rubric too? Because I have it in the answers, but it's easier when you
Broke it down? All right, I'll send this too. Now, next one is conflict preemption. Here again, this is 4 points, but it's not, it's with respects to implied or conflict preemption. It does not appear impossible. So now we start for the private party to respond to the federal and state requirements. Thus, it is unlikely that the court will find that preemption on impossibility grounds. Then she goes and adds some facts. Hot-speed-jet likely will argue. So now we have some counter arguments. Likely will argue an obstacle to preemption, claiming that it is being negatively affected by the workers' compensation payments, limitations, impeding the goal of the mandate. However, because state law does not set prices more broadly, its concern is likely insufficient to support a conflict preemption based on state law impeding the federal objective. But I do want to say this. You don't have to conclude like this. You could come out the other way. You can say it does. You understand? This is how the professor, like there's no right answer here. It's all about the argument. If you can make an argument that it is, make that argument. You don't have to, there's no right answer. It's all about making the argument. This is an example. This is not the end all be all. And again, this is worth 4 points. Then we'll go to field preemption. And here, this is not that long. Field preemption is also unlikely. So she's saying none of these apply. While the federal statute contains language that by itself could indicate the intent of Congress to occupy the field, the safe harbor language that is also provided in the statute indicates an intent to leave the space for states to legislate in ways that Wyoming has under its workers' compensation statutes. She says none of these apply. So these are all quick raise and resolve, raise and resolve, raise and resolve. And then we're on to the next question. So here, we've gotten all the points. First, most of them were in a rule and rule explanation, 15 of the 25, and the other 10 were just really raise and resolve. This is why express preemption doesn't work. This is why implied preemption doesn't work, even though in my answer, I put implied preemption does work, or conflict preemption does work. They say here it doesn't. Field preemption, it doesn't work. And here are the reasons why. So again, now when you're preparing for this exam, now I think everyone in this room has a better understanding of what the professor's looking for and what to spend your time on, right? And what's going to get you the most points. Any questions? No. All right. Going once, going twice. Go ahead.
Just curious, for your view, you said it does apply for preemption, field preemption, but since model answer says it doesn't,
Mhm.
you would make an argument for both, or just open one feel stronger?
Oh no, like I would make all these analyses, and then if like I came out the other way on conflict preemption. I came out the other way. I said it did apply, but it doesn't matter as long as you make the argument, understanding what it was, and then make the argument. Should be fine. Like you don't have to come out the way she came out, but you have to make the argument. Did I answer your question? Did I? All right.
You don't have to go to a certain view.
No. It's all about the argument that you make and the facts that you use, and you can apply it. Now, question? Good. All right. So here, one of the biggest points that I definitely want you guys to take away from just looking at these first two examples is that the professor, it seem like the bulk of your points are really coming from the rule and the application. Now, the rule explanation is important. I think it is important because you're going to have to use some of the knowledge that you have from the cases in your rule explanation. But it seems like really understanding the rules and how to apply them are going to get you the bulk of the points. And the rule explanation is more or less the ice cream, the whipped cream on top of the ice cream. It's an additive. It's going to get you more points, and you should strive for the most points possible. But in your studying, you should really, really start focusing in on the rules and how to apply these rules throughout. Now, I know that's just, it's easy to say because that's usually the hardest part, but that's what you really want to really be focusing in on. So let's go to the last one. Now, unfortunately, for me, let me see if I think I deleted the end of my PowerPoint. So I'm going to have to do this one from memory again, but I am sorry because I don't know what happened to the rest of my slides. I think I was trying to transfer them over and I think I deleted them by accident, but it's okay because it's all here. So here, for the last one. Now the last one is only worth 10 points, and I always say this: you should start with the 225s and save this for last because this is it's nice, but you really want to get the bulk of those points, and then just So even if this was the first question, obviously you want to probably do the ones that have the most points first, especially on this type of time test. Because it's going to be 3 hours, and you don't want to be same situation where I think a lot of students may have been with evidence, where you're just going through the test and not really paying attention to which questions have the most points. Because that's where if you run out of time, you'd rather run out of time on this. This happened to be the third question, but you're going to run out of time. If you rather run out of time on the 10-point than the 25-point, all right? So that's just a test taking tip. So here we're doing the 11th Amendment analysis about. Is Hospijet barred from bringing any action under the principles of state sovereign immunity? So here, without even looking at the answer, does anybody here think that they're barred for bringing this action under state sovereign immunity? Because they're suing for their money back. Who thinks they're barred? People who read the fact pattern. Who thinks they're not barred? Why?
Would you say that states have the
This 11th Amendment, just 11, sorry. Mm-hmm. Well, let's go back. For sovereign immunity, for the 11th Amendment, what's the principle that it bars? How does the 11th Amendment work? What's the rule? Anybody want to help him out? Go ahead.
I was just gonna
She said the 11th Amendment's not going to be tested?
Yeah, that's what I heard. Because she said,
Yeah.
chart, right? These two,
Let me see.
think of these two columns are not being tested.
All right. Also, actually, we went over. All right, so she did put the 11th. Oh, she did put the 11th Amendment here. I thought it was all right. All right, so you know what? Forget about everything I just said.
I mean, we can still
She said it's going to be there. Nah, she hasn't seen that. Then I got to speak to her then, because she can't. Because if she gave you that, then then we're gonna have to. We gotta. Yeah. With that paper, and she said it is.
I told him that it wasn't on there.
If you up there, you can ask them.
Well, you know what? Well, you know what? Let me go over this, and then you guys do your lawyer thing and go up there and raise hell. But so, but just in case, because if it is now, you guys got a nice little soft ground ball, right? Because it's right here. Here's the full analysis. So, but yeah, hold on. I got a quick question. Number 2, preemption because state impedes achievement, federal objective. Was this covered? I believe it was, but I'll check again. This was for James. I will check to see if it was covered, but I'm not sure. I believe it was covered. All right. So for the people online who weren't part of the conversation, there was 11th Amendment was on the piece of paper, the coverage area for the class. The 11th Amendment was on the section that was not supposed to be being covered at this time. So some of the students have said they spoke to the professor and she said it was going to be covered. So since there seems to be some doubt about whether it's going to be covered or not, I'm going to just go over this last piece because it does deal with the 11th Amendment, and we'll see. So let's go right to the rule for the 11th Amendment. The 11th Amendment immunity, state sovereignty. It limits the power of the federal judiciary to hear claims brought by plaintiffs of other states, other than the U.S. and another state, against states as defendants, their agencies, state officers, sued in their official capacities, unless, so here's the exception, and that was the state has unequivocally waived the 11th Amendment sovereign immunity, or Congress has unequivocally abridged immunity through the exercise of power that authorizes abrogation in Seminole tribes. So now, here we have our rule explanation. So here we have the rule. She's laid out, and she snuck in this rule explanation here, where it goes, in Seminole tribe, the Supreme Court held that Congress had no authority under their Commerce Clause to abrogate states' 11th Amendment immunity, and suggested that no Article 1 power authorizes abrogation. So what does this actually mean? This means if you're using the Commerce Clause, if you're using taxing and spending, and the question comes up about the 11th Amendment, that means you cannot abrogate sovereign immunity using one of those two powers. That's what this is saying, right? Because the Commerce Clause and the Taxing and Spending Clause are found where? In the Constitution. Article 1, Section 8. And this says Article 1 powers, it suggested that no Article 1 power authorizes abrogation. So we cannot abrogate sovereign immunity using the Commerce Clause because of Article 1, nor can we do it with taxing and spending. Now here, one thing I also think is interesting to note is here, it's an interesting little quandary here, which when I was looking at it, I thought was fascinating in the sense that here we have hospicare. They're saying that they're owed more money because the federal government says you can only price up to this point. And I mean, the federal government allows them to charge more, but the state government has capped them down here. So there's a difference in between what they can get from the federal government and what they are getting from the state government. And they're asking for that difference back. So that difference, so they're literally trying to sue the state to get that money back. And that's what this piece is about. Can they get the money back? Because first you have the injunction trying to say, well, that state law is preempted or through some way or not good. But then you also have the secondary piece where, hey, we want to actually now sue the state to get those funds back. Now, they could do it through states. If I was litigating it, first thing I would say is, well, if we can get the state statute invalidated, then we can sue in state court to get our money back because the state law is invalid. But here, we're trying to sue in federal court. And since we're trying to sue in federal court, sovereign immunity would kick in, and you could not, and this suit would not be able to go forward. Did I just confuse you guys all or no? Anybody have any questions? Because I know I said a lot there, a mouthful. Here, again, from this point at the bottom, let me highlight for the people online. From this point at the bottom all the way up from the rule. This is the full rule, and this is all worth 4 points. Again, we go back to the principles of the sovereign immunity. This is going back to our rule explanation. We have our rule, we have a piece of the rule explanation, then we have this rule explanation here, explaining, again, this is going back to, why is this not going away? There we go. Explaining to us what sovereign immunity is, how it developed, and what it really means. The 11th Amendment restricts judicial power under Article 3. And Article 1 cannot be used to circumvent the constitutional limitations placed upon the federal judicial jurisdiction petitioner suit against the state. So this is, even though it's saying what it says up here a little bit, it's kind of just flushed out. And again, this whole thing is worth 4 points. You have the rule and rule explanation. Then the next piece, we're going right into application. The court has, however, oh, no. Actually, we're not going into, we're actually then going into another rule conferred by Section 5 of the 14th Amendment. Congress gives authority to abrogate the 11th Amendment. So now we've gone from rule to rule explanation back to rule again, because now we're talking about the 14th Amendment. If, on the other hand, the 11th Amendment applies, it bars private suits. So this is a lot of rule explanation here, going through this. It's funny because when I read this the first time, I didn't realize how much rule explanation this really was. But this is like all rule explanation. Explain and it's kind of saying the same thing again too, right? If, on the other hand, the 11th Amendment applies, it bars. We already said that twice. Ex parte Young, it does mention where you can sue state officials. Again, this seems to be going through the whole piece of the 11th Amendment, because these are all the things that we talked about during the 11th Amendment. Ex parte Young, how you can sue them. So this is giving you a full explanation of it, especially against money damages, not available under Ex parte Young, but you can get injunctive relief. So this is giving you a full breadth of what this amendment is. So the first part was 4 points. This part is 10. This is just elaborating. This seems like to be a fuller example of rule explanation and giving you an example of Ex parte Young, where you can get injunctive relief but can't get monetary damages. And that's all worth 2 points. Again, I know it seems to be a lot for 2 points, and that's what you're thinking about right now, right? You're like, all right. But this is the 2 points. So right now we're 8 points in. So the last piece is worth just 2 points. Oh no, did I do the math wrong? 4 plus 2 is 6. Yeah, so it's 4 points left. You got it, you know. So here, because this is your conclusion here. No intent to abrogate, no express intent to abrogate, no power under Section 5th of the 14th Amendment, no waiver by the state, no suit by against state officials, therefore no authority of hospital to sue state of Wyoming for damages or otherwise in federal court. You get 4 points. So, just so we can be clear. So this example, we went through the left, can't do it under sovereign immunity, can't abrogate, right? Article 1 power. This is not about Section 5 of the 14th, because this is Article 1 power. This was, if we're trying to, since this is commerce, Section 5 of the 14th Amendment doesn't apply. But remember, if this was equal protection, we're talking about something different. Equal protection will apply. For the 5th Amendment, Section 5 of the 14th Amendment would apply to an equal protection clause. But this is commerce clause, so it wouldn't apply. Go ahead.
So 4 points to say what does not apply.
Yes. That there's no, the reason why this is saying it, it's kind of saying it in reverse. In other words, it's saying first, no express intent to abrogate. So Congress, so generally, if you're trying to abrogate, you have to have the express intent. They have to say it, right? And no power under Section 5 of the 14th. So they're saying, under Section 5 of the 14th, nothing. No waiver by the state, because you had a waiver that would get you over the 11th Amendment, right? There's no waiver, so you don't have that. This is saying no suits filed against state officials. But if they were to follow suit against a state official, you can't get monetary damages, but you can get injunctive relief. And then it says, therefore, no authority for Hospijet to sue the state of Wyoming for damages. That's your 4 points. So I know you guys are looking. So as we can see, very consistent with the grading. Rule explanation, except for the second question, rule explanation was kind of wrapped up in the rule a little bit, right? So you kind of had that little mingled piece, but otherwise, rule explanation at the top, rule explanation at the bottom, with the cheapest points, 2 points at the top, 2 points at the bottom. Here, this last paragraph gets you 4 points. What is it, 2 sentences? But again, you have to explain what, you don't get this, you don't get this, you don't get this. And I would actually put, well, the first one is actually, this is here, no express intent to abrogate and no power under Section 5. So this is the 14th Amendment. Here is I would put the 11th Amendment. There is no waiver by the state, and I would put something about the 11th Amendment in here. Just let her know that's what I'm talking about. No state officials. I would put ex parte young in this, and then I would just close with that. And then I get all my 4 points. No doubt about it. And then we close. So I would say this. I would say go forward, go back. And can I see that paper again? I should have looked at this before. So what we're going to be tested on. And it seems like a very, very closed universe of things, which is great. But since there's a question on the 11th Amendment sovereign immunity, I'll put that to the side. But you're really talking about the Commerce Clause, talking about necessary and proper clause, which we saw. Necessary and proper clauses, if you're talking about the Commerce Clause, it's automatically going to come up. So that's something you'd have to know. If you're talking about taxing and spending, right? Conditional spending. Again, taxing and spending clause issue comes up about then looking at necessary and proper clause. We're talking about we have the 10th Amendment, we have preemption, and we have the Dormant Commerce Clause, and then we have Article 4, Privileges and Immunities Clause. And I talked about that. If for those of you who don't get my emails, I sent out an email with a video that expresses all of these actual rules, explain how they work and the cases. And I forgot to mention too, the page numbers on the video are identical to the page numbers in your book right now. So you can actually, so when it has the page number to say, okay, here's an example of it on page 454, that's actually the page number in the book you're using right now. So you can just look and see that illustration too. So it actually gives you the page numbers for the sources so you can look at them yourself, and the cases so you can look at them yourself. Anybody have any questions? All right then. So I'm going to stay for more questions. For the online people, don't forget about Sunday, for everyone actually, for Sunday at 2 o'clock. We're going to be doing this for family law. I sent out 2 documents for family law. You should have them. You should read them. Understand that the test will be on those 2 documents. This is a closed universe of stuff. It is an open note test, so you guys can bring in those notes. I'm going to be sending out a couple of questions so you guys can start answering them too. I will be here Sunday with the professor so we can go over some of the stuff. We're still looking over the test right now, but the test will hopefully be finished up soon. It shouldn't be too heavy, but it will be on some of the stuff that on those 2 documents that I have already sent out. It will not be anything more than that. And I can say one thing: good luck to everyone, because I know this is a very stressful time. And again, you guys can look over this video again. So I'm going to then end this video. Thanks for the people who are watching, and we will see you next time. If there's any last questions, I'm watching the screen, so let us know. 5, 4, 3, 2, 1. No other questions? All right. Hey, you take care too. Have a great night.